and welcome to the InFocus series of Drishti IAS. I am Ritu and today's session is about Post Office Act 2023, and this session is important for your GS2 perspective. Before moving to the points of discussion, first of all you should know that before this digital world, post office are very important and you can say backbone of the communication line. Right now also it is very much important when it comes to the parcel, when it comes to the official letters, when it comes to the shipments of various goods and services. So that's why it's very important that how post offices in India are regulated to know. So moving towards the points of discussion part. First of all, we are going to discuss the news, then we are going to discuss Indian Post Office Act 1898, then we are going to discuss Post Office Act 2023 and highlight about this thing. Then we are going to discuss the concerns related to this particular act. After that, we are going to discuss the way forward, and then we have to discuss practice question for prelims. Before that, you have to like, share and subscribe to the Drishti IAS channel. Moving towards the news part. So on 18th of June, what had happened that the Post Office Act came into the existence, which was already passed in December from the Lok Sabha and Rajya Sabha. So that's why we are discussing this particular news, that how this particular act is important to us. And in this examination, you can see that how much current affairs is useful for us. So it's very important to know the provisions of this act. And also we should know that what are the advantages and disadvantages of this act. Moving towards the next slide. Next slide is about the Indian Post Office Act 1898, because this thing should be studied by us, because this act has been repealed by Indian Post Office Act 2023, and after repealing this act, the new act came into the existence. And why it was repealed? Because it was outdated, it was given by the colonial powers. So it's very important to have our own kind of act which suits the Indian condition. So it came into force on 1st July 1898 with the objective to consolidate all the postal services of the country, of the then colonial India, and also it provides regulatory measures. It means regulation of the postal services offered by the central government, and in it the power and exclusivity has been given to the central government. So central government has exclusive privilege over conveying letters and establishes a monopoly of the central government over conveying letters. So this was the feature of the Indian Post Office Act 1898. Now we come to this act which has been enacted now. So first of all, we'll here study the highlights of this act. So we have this one provision, Director General of Postal Services. So what had happened into this provision? That Director General of Postal Services has the authority to make the regulation of pertaining activities, and if there will be any revision of charges, lowering of charges or increasing of charges, that can be decided by the Director General. So it had reduced the parliamentary procedures and parliamentary approval kind of things. So it has eased the process. Now we come to the interception of shipments. So this act professes that the central government may by notification empower any officer to cause any item in course of transmission by the post. And interception can be caused on the basis of these grounds: if there is the threat to the security of the state, friendly relation with the foreign state, public order emergency or public safety, and occurrence of any contravention of any of the provision of this act. So on the basis of these provisions and on the basis of this thing, anything can be intercepted for the shipments. Now we come to another one, which is about the identifiers and post codes. So identifiers and post code would be replaced from physical to the digital thing. And this is a very good step, because we are living in a digital world and it's very important that it should be digitally coded. So it should be digitally coded along with the geographical coordinates. Then we have removal of offenses and penalty. So this act does not contain the punishment for the theft, misappropriation or destruction of postal articles by an officer. Earlier it was there in Post Office Act 1898. So this act has this kind that there is a removal of the offences and penalties if anything done by any officer. Now we come to the penalty under section 7. So every person who avails and who uses this kind of services, they had to be and they are liable to pay the charges in respect of their services. And if anyone will not pay, then the government will compensate with other means. Now we come to the another one, which is remove center exclusivity. So earlier what we have seen that the center had this monopoly on conveying of the letters, but this time this particular exclusivity has been improved, or you can say removed. So this section 4 of this particular act 1898 has this kind of provision, but this time we don't have such kind of the provisions. Now we come to the another one, which is about the what are the concerns. So these are the highlights we had studied. Now we'll study that what are the concerns related to this particular act. The first thing is that regulation of postal services different from the courier services. So earlier the courier services was not part of the particular act, and the courier also came late. It was around 1890s, and after that courier service were free. But this time we have the courier services under the ambit of this act, which is somewhat good also because it is regulated. But if it will be regulated a lot, and so there will be the what you can say restriction on the freedom of different kind of parcels and shipments. So there is also one of the thing. Then lack of procedural safeguards violates fundamental rights. So opposition leaders had also raised question on the fundamental rights, because they had this provision that if they find anything problematic with any kind of shipments, then they had right to stop it from any kind of thing on the name of national security, on the name of the friendly relation with the other state. So that has also a question on the fundamental rights, which is the right to privacy. Now the ground of emergency is beyond the reasonable restriction. So they had said that in emergency situation, or if any kind of thing, they had right that they can intercept the shipments. But the ground of emergency is not clear here. So it should be made clear here. Exemption from liability for lapses in services. So earlier we have this provision, and the railway is also commercial service provider, and railway had also that if you lapse any kind of offering the services, so they had this liability to pay. But this time we don't have this kind of thing. Then removal of all offences and penalties. So you have seen that in 1898 we had this kind of provision, but right now if any officer commits any kind of delay or misinform any kind of delay in the service, then the officer will not be what you can say punished, or there will be no any penalty on that officer. So this is also one of the loopholes, and also lack of clarity on consequences in certain cases. So the rules which has been specified in this particular act, it lacks the clarity. So many, the letter word has this kind of confusion. The courier service provision had this kind of confusion. The emergency provision had this kind of confusion. There is also confusion related to the penalty services. So all these things lacks clarity, which should be clarified immediately. Now we come to the way forward, that what would be the solution for it. So incorporate robust procedural safeguards, define the grounds for interception, balance liability framework addressing unauthorized opening, because it has certain provisions related to it, like you can see that if there will be any problem thing related to your article, related to your shipments, then the officer may open it, and they can also halt it also. So in such situation there is also attack on right to privacy. So these kind of things, these kind of nitty-gritties should be removed, and there should be more clarity on each of the what you can say procedures of the particular act. And also there should be the provisions on the penalties, because if there will be no provisions on penalties, if there will be no rules for the officer because of his or her mistake, if there will be the delay in shipments, if there will be the problem of theft of any kind of articles or shipments, so there should be definitely a provisions for these kind of officers and the officials who are present there, and those who do any fraudulent activities in the name of postal services. So there should be the punishments related to it. Now we come to the question part. The question is related to the right to privacy, because this issue has been raised by opposition a lot. So right to privacy is protected under which article of the Constitution of India? Article 15, 19, 20 and 29. So this is very easy one. You have to answer this into the comment section. I hope you like this session. If you have any queries related to this session, kindly ask in the comment section. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.